black family's lawn was not a threat? And the answer is, it is a threat, and it can be a threat. But the statute in St. Paul didn't ban threats. It banned annoying and harassing behavior. I'll get to harassment in a second. There was another Supreme Court case called Virginia versus Black. It was a Virginia law where they prosecuted a guy for burning a cross, and similar facts. In that case, the statute was threatening someone. And when you burn someone as part of an act of threatening someone, where you're intending to threaten that person, that was sufficient to justify a prosecution because a threat is a crime, right? If I go up to you and say, you know what, Joe, I'm going to beat you up, right? I'm going to kill you. I'm going to kill your family. Those are words, but I can be prosecuted for threat. Now, there's always a discussion, was it intentional, right? Was I being sarcastic? There are all the various defenses you can raise, but you can prosecute someone for threats. So there's not a problem if the cross burning is part of a threat. But there's no, the statute in the St. Paul case wasn't about giving threats. It was about just annoying and these sort of harassing contexts. I'll get to harassment in a second. I keep tabling that. All right, but does that at least make sense about the threats? All right, so usually at this point, someone says, well, Josh, what about harassment, right? What does harassment mean? This is one of those words that First Amendment lawyers are very skeptical of. Because depending how you define harassment, a lot of speech can be put under that umbrella. And if we say that harassing speech can be punished, then that's potentially a broad category. So usually when you think of harassment, you might think of sexual harassment, right? We're not talking about physical touching. That's a battery. That's a different story altogether. But imagine in a workplace, some boss is always hitting on an employee and propositioning her for sex and making comments about her appearance and stuff like that. That's what's called sexual harassment. And if you ever had an employment law class or if you worked in a workplace, you know what that is, or at least you should know what it is. And it's not allowed. And the courts have allowed the government to impose liability for people who make these sort of comments. But there's a lot of requirements. It has to be severe or pervasive. It has to be ongoing. It has to create a hostile work environment, right? These are terms that exist in the employment context. But if I just go down the street and I call someone an asshole, right? Or if I bother someone, that might be harassment in the colloquial sense of the word, right? But it's not harassment in a legal sense. Merely engaging in speech someone doesn't like is not harassment, at least understood as it's been understood. That the term may change in the future, and I fully expect it probably will. But as it's been understood, harassment is not annoying someone, right? Which is why in the cross-burning case, merely using the word harassment in a statute doesn't get you home, right? The threat mens rea does it, but merely an intent to annoy is not sufficient to justify prosecution under current law. That might not be the law in a decade from now. And in fact, I've long expected the courts use the harassment label to expand the scope of speech that can be regulated. So I am giving you the law as it is now, but also I'm hinting that things may change for the future. All right. Questions, my friends, on harassment or on cross-burning or on fighting words or on viewpoint discrimination? This is a lot I'm throwing at you, but I want to try and get this as clear as I can. No? Okay. The last thing that people ask me about in class on Wednesday concerns strict scrutiny. Now, you've all taken con law, and you've probably spent a lot of time on strict scrutiny. If you had me or Professor Rhodes or Kelso, you maybe learned that there's no single strict scrutiny. There's a type of strict scrutiny for the Due Process Clause. There's a type of strict scrutiny for Equal Protection Clause. And guess what? There's a type of strict scrutiny for the First Amendment. And it's not even that simple. There are different types of scrutiny for the First Amendment. There's strict scrutiny for speech. There's also strict scrutiny for free exercise of religion. There's strict scrutiny for the Establishment Clause. There might be strict scrutiny for the Second Amendment, right? The court uses a phrase strict scrutiny in so many different contexts to mean many different things. So let me try to summarize as neatly as I can. When we're talking about strict scrutiny for free speech, the government has a very strong burden to show that they're using very narrowly tailored means, right? Means that are not overly broad, right? You try and restrict as little speech as necessary to get to compelling interest. I would encourage you not to try to kill yourself to think about what strict scrutiny means in this topic, because generally a free speech law reviewed with strict scrutiny is unconstitutional. I mean, that's the general rule. The harder question is it subject to strict scrutiny, or is the law subject to intermediate scrutiny? With the O'Brien test, if the rule is not related to the suppression of speech, then you give it intermediate scrutiny, and generally it survives that. But if the law is directed towards the suppression of speech, then it goes to strict scrutiny and it fails, right? The draft card burning law was not designed to suppress speech, the court said, therefore it survives. The flag burning law was designed to suppress unpatriotic speech, therefore it's unconstitutional. So rather than kill yourself in deciding what is and is not strict scrutiny mean, the different tests, I would focus more on deciding, does it get to strict scrutiny, right? That's the threshold question that really matters. Okay. Whew. I don't like to lecture that much, but there were a lot of questions I want to make sure I got through. Questions? There are 87 people and not a single one has a question. Okay, good. Ryan, thank you for letting me know I'm not talking to an empty room.
Sure. The scrutiny, so the burden's on the government. Is there a specific type of interest they have to show? Any conceivable interest, or is it like a compelling?
Yeah, for strict scrutiny, it's got to be a compelling interest. That's usually the rule. The reason why I'm hesitating is a court has framed the test slightly different contexts, right? Even with, you say due process clause stuff, they don't always say it the exact same way. There are different tests. Is it deeply rooted in history? Is it about dignity and all this other stuff? I stopped myself, right? These are not tests that are easy or even important enough to understand. The more important premise is to know how to get to the right tier of scrutiny. Because once you get to strict scrutiny, the government is going to lose, right? It's going to be very hard for the court to justify a restriction on speech that is reviewed with strict scrutiny. It's just, you're going to lose. That's the general rule. Okay? All right, thank you for that, Ryan. Anything else? All right, then let's segue to our topic for today, which is money and speech. And this is a very hot topic, and it seems to always be very controversial. So I want to start off at a very simple level and just ask a few questions. Who's next up on the queue?
I think I am.
Okay, is that Tori?
Yeah.
Okay, Tori, thank you. So, Tori, let me ask you a question, right? If a person wants to speak, this is going to sound like a stupid question, but it's not, right? If a person wants to speak, generally, what do they have to do?
Open their mouth.
Okay, and then what? and then what?
You're articulating what you want to say in words, usually through writing or speech or something like that.
Okay, and so I assume you're sitting in a house or an apartment somewhere in Houston. Okay,
Yeah.
so if you want to speak to people and you start opening your mouth in your apartment, does anyone actually hear you?
Hopefully not.
Well, say you want people to hear you.
No, you would be using electronic means these days.
Okay, so you might go on Zoom, right? You might call someone. Maybe you yell out your window with a bullhorn. What if you want to convey yourself through writing? What would you do? Sounds like a stupid question, but it's not.
I mean, I would say send a letter, but these days it's more of a text message or an email.
Okay, so you email someone, maybe you tweet, maybe you put a stamp on an envelope, right? Are all those things free?
Internet connection aside, yeah, usually.
Is a stamp free?
Definitely not.
Is a tweet free?
Is what?
Is sending a tweet free?
I mean, the account is free, right? You don't have to pay actual money for it.
Does Verizon or AT&T give you a free phone? Or
Definitely not.
no? Is paper free?
No.
Is a pen free?
No.
Okay, so really, other than opening your mouth and moving your lips with your, making sounds, is it possible to have free speech?
I get theoretically no, I guess.
Yeah, thanks, Tora. Sorry, I know that sounded very obstacle, but it's a very fundamental point. When we're discussing money and speech, I want to start with a very basic premise. In order to speak, you need to spend money. Of course, I'm sitting, open my mouth, I'm speaking, but I have an expensive laptop in front of me. I have an internet connection. I have a Zoom account. I have this lovely light ring that makes me look glowingly, right? I have a microphone next to me. If I want to send a tweet, I need a smartphone. I need a data plan, right? If I want to print flyers, I need paper. I need ink for my printer. I need a printer. If I want to hand out brochures, I need to go hire a printing press to do that. I suppose I can go to a park and stand on a soapbox, and everyone in the sound of my voice who can hear me, will hear me. But if I want to reach people who are not in front of me, I'm going to need to spend money. Maybe I'll buy direct targeted ads on Facebook, right? Maybe I'll put a commercial on the TV station. Maybe I'll put an ad on the radio. Maybe I'll sponsor a movie to convey my idea. Maybe I'll write a book. Maybe I will hold a rally by the White House. I keep going back to that, don't I? Right? In order to speak and convey an idea to a large group of people, or any group of people, you have to spend money. You can't get away from that, right? And that doesn't mean Citizens United is correctly decided. I'm not trying to convey that, but I'm saying at most basic level, you have to spend money to speak. Okay? Now, so far, I haven't said what I'm speaking about. So let's say I'm speaking about, poetry, right? Or let's say I'm speaking about art or music. If I want to have a music podcast, right, I need to spend money to have a music podcast. If I want to have a concert, I have to, put together money to get speakers and equipment. Generally, there's not much opposition to spending money on those sorts of types of speech, right? But art and music and literature, everything else. But politics raises a different issue, right? Allison, you here?
I'm here.
Allison, help me out here. Why do you think spending money on politics feels so much different than having, say, like a music podcast, or putting a concert together about with people performing classical music?
Because politics kind of influences everyone with the outcome, and for the other, it's kind of your preference if you want to go to that or listen to that. And I mean, you're trying to reach as many people as possible, but I guess you're not affected as much in the end.
What's the risk, Allison, if people are spending money on expressing political opinions? And we'll just take an easy example, putting a commercial on the radio saying, I support candidate X and I oppose candidate Y. What's the risk of having that sort of commercial?
That people will not really know the reasons why, or you might influence them without all the facts.
So what's but putting aside, the reason why I'm putting on it, what's the risk of me supporting candidate X? Why is that potentially problematic?
Because someone else may not be able to afford to do it.
Sure, right. There's an equity issue, but my question is a little more fundamental. Why would society perhaps be troubled by a person putting a commercial on the radio or TV saying support candidate X?
Because they might have a different view and people start kind of pitting against each other.
No, it's not it. Matthew, here?
Yes, sir. Yeah, I think it's the motivation of the person. Like if you have enough power to sway people's votes, and then you're doing so with a bad motivation or a selfish motivation, like a corporation, I guess.
But who cares what my motivation is? I can't change policy.
Well, you can give money to someone who can change policy.
Well, I'm not giving money. I'm simply putting a commercial saying I support candidate X. I've not given a penny to the candidate.
Well, if candidate X knows that you're supporting him,
and what might my commercial supporting candidate X accomplish?
Gaining favor.
And what happens if a person has favor with a politician? Now we're getting closer.
They get favorable treatment.
And what happens when a member of government gets favorable treatment to one constituent?
The other constituent gets screwed.
All right. Thank you, Matthew. I think we're close now. Okay. So the risk, and Allison wasn't wrong, just it wasn't the answer I was looking for. So you weren't wrong, just wasn't the answer I was looking for right now. The risk is of corruption, right? If people are allowed to spend money to express certain political viewpoints that's aligned with a given candidate, there's going to be a fear that the donated money might be considered, I won't say the word bribe because bribe's very different, but it creates a risk that, I think Emma put it well in the chat, there's a constituent will have an obligation to the supporter, right? That the politician will feel obligated to help out the person who gave money. It's like, wow, I need to get reelected in 2 years. Joe Smith gave a lot of money to support my campaign. There's some legislation that Joe Smith cares about. Maybe I should consider Joe Smith's views when I vote for that legislation, right? Joe Smith doesn't like that law. He doesn't want it to be law. Maybe I should vote down the bill. And the risk becomes that government is no longer going to be sort of, I don't want to say objective because that's the wrong word, but government will become beholden to the interests, right? That a member of Congress who might go into an issue undecided will be swayed by those who write the biggest check. Perhaps not bound by it, but swayed by those who write the biggest check. Genevieve, you here?
Yes.
So Genevieve, do we believe for a second that members of Congress are neutral? Figuring aside the money stuff, do members of Congress have favorites?
Yes.
Of course they do. Do you think, how serious do you think this corruption risk is in politics? In other words, how much of a member's vote do you think is actually affected by the amount contributed?
A lot, seeing how much is spent on campaign finance, and again, which we read about the PACs and everything. I think it's greatly affected by that and the amount of money people who are willing to donate.
So in other words, if it wasn't so useful, people wouldn't give the money. Is that what you're sort of getting at? Yeah. Okay. Thanks, Genevieve. All right. So what I'm articulating here is what's called the corruption, or maybe the anti-corruption principle, called both ways. And the idea is, if money is flowing into politics, it could corrupt members. Like there are these innocent bystanders, like, oh my God, you corrupt me with your money, right? Without the money, they'd be these innocent bystanders, but that's the idea. Now, when Congress enacts these campaign finance laws, the courts don't require them to actually show corruption, right? That they actually had a quid pro quo, that Joe Smith gave money to candidate X and candidate X voted for a bill because of that. It's enough to show the appearance of corruption. That's a phrase used in Buckley and in McConnell. The appearance of corruption. Now, what's the difference between a corruption and the appearance of corruption? Well, the appearance of corruption, you don't have to actually prove there was corruption. All you need to show is that someone kind of like a reasonable person standard, I guess. A reasonable person looking at this would say, wow, giving a $10,000 donation to this candidate. I'm sorry, I said donation, I should use the right terms. Giving a $10,000 contribution to this candidate. Yeah, that looks shady. That looks sketch, right? Or sus, as we would say, right? That's no good. You can't do that. Even if everything was above board and the member was completely pure and honest, as all members of Congress are, it wouldn't matter. Okay. So at the base level, Buckley turned on this corruption principle or anti-corruption principle. Right? It's the notion that Congress has an interest to regulate speech to avoid that corruption. In Buckley, the court basically agrees that spending money in politics is speech, right? That's not even an issue. That the court is like accepting that. And they follow the O'Brien test, and they find that this is speech. But this is one of the rare instances where the court actually finds a law that regulates speech is permissible. All right, so I didn't ask you to read Buckley because it's a very long case, and frankly, Randy and I have decided to actually remove it from the next edition of the book. It's gone. It's gone. So the next edition of the book will just have a summary of the case. So I'm not going to make you read it anymore. But the issue in Buckley was the FECA, the Federal Election Campaign Act from 1971. And the FECA had two kinds of regulations. The first is a limitation on contributions. And make sure you get your terminology straight. I said donations before and I screwed up and I corrected myself. The right word is contributions. Contributions is money spent directly to a candidate's campaign, right? I write a check to John Doe for president. The second type of restriction is known as an expenditure ban. Expenditure. What's an expenditure? Expenditure is money that's spent by people on behalf of the candidate. So let's say you're running commercials and advertisements on behalf of the candidate, right? It's not actually giving it to his campaign funds, but you're spending money on behalf of him. And these are coordinated ads, right? You're working with him to put commercials on TV. Okay, make sense? Excuse me. Buckley was a very long and complicated opinion, but it's split roughly down those two lines. The court held that you could limit contributions, right? Why? Because giving money directly to the candidate could be seen as a form of corruption. You're literally putting money in his bank account. Okay? But then you have these so-called independent expenditures, right? These are not coordinated at all, right? Where you're putting an ad on TV saying, I support, John Doe for Congress, right? He's a good guy. The court allowed those, and they said that they can't put limits on the expenditures, right? You can't put limits on the expenditures. So you have this line. Contributions were okay. You could ban those or regulate those. But expenditures were more protected. You couldn't put limits on expenditures. Okay? I'll get you a second, Macy, I promise. So long as the money is being spent independently of the political campaign, Congress could not regulate those. And the court also held that money given to political parties could not be restricted because the same risk of corruption was not present. All right, Macy, go ahead.
Yeah, I just was wondering why the court makes this line between expenditures and contributions, because to me the risk of corruption is the same. Like nobody truly goes out and spends money on a campaign in no coordination with the candidate.
Well, just be careful there. The coordination line is actually important. They actually have to take steps to distance themselves between the campaign and these committees. If there's evidence of coordination, they in trouble. Now, generally, you don't need to have coordination because everyone knows what they need to do. But if there's express coordination, they lose the benefit. Right? Gavin says you could launch an ad campaign without their knowledge, and that's fine. In fact, I'll just give you an example of how ridiculous this is. One candidate recorded a video of himself just sitting at a desk smiling, right? Basically footage, which people could then use in their own campaign ads. He didn't tell them what to say. He just recorded a video of himself sitting at the camera smiling, looking for 30 seconds. He can be used in commercials. So people go to great lengths to avoid interaction. That makes sense?
Yeah, I guess my hangup is just that, like, in real life, in real practice, nobody is actually completely independently, for no reason, launching thousands of dollars to campaign ads just because they have no connection with the candidate.
It's not right. It's not about not having a connection. There's less of an appearance of corruption. That's the issue, right? Because there is some degree of independence, there's less likely to be this sort of connection. Now, if I'm the candidate and I'm watching TV, I say, "Oh wow, John Smith ran an ad for my benefit. That was really nice of him." Right? That could perhaps still affect your vote, but it's not as much of a risk of corruption that there's just sort of quid pro quo, I give, you give, right? There's this close connection when you're working in tandem, right? With a contribution, it's straight up, I'm giving you money, I'm writing you a check, right? Imagine I go to a party and I'm talking, you say, oh, look, I have this check for $5,000. Let's talk for a bit. Let's talk about some pending legislation. You know what? I like how you see things. Let me give you this check, right? The risk of corruption there is far greater than running an ad on TV that the candidate might see. But I don't think this is persuasive. I'm just telling you what the argument, what the argument is on the other side.
Gotcha. Thank you.
My pleasure. Again, this is a very divisive area. I don't want to even try to say this is simple. This is many books have been written on this issue and criticisms of Buckley. Why the hell do they draw this line between the contributions and the expenditures? I could not really tell you. I mean, I can give you a theory, but it's not very good. We don't really know. We don't know exactly if this was even the right line to draw, but it's a line we're stuck with. That's what we have here today. All right, so that's Buckley. Fast forward about 30 years to McConnell v. FEC. This case was 2003. And McConnell represents a different type of law. Congress enacted what's called the BCRA, the Bipartisan Campaign Reform Act, the BCRA, often called McCain-Feingold, after John McCain and Russ Feingold, the senators who sponsored it. This law did something different. It prohibited specific types of advertising, what's called electioneering. Okay? So imagine, 30 days. Sorry, it's 60 days for a general election, 30 days for a primary. So imagine 60 days before an election, you want to put a commercial on TV criticizing a candidate. This law says you cannot do that if you use corporate funds. Now, let's be realistic here. Everything is corporate funds, right? It's impossible to make a TV commercial without a corporation, right? Even like a small, one-member LLC. I suppose if you're a sole proprietor and you make a commercial by yourself without involving anyone else, you can perhaps get around it. But for practical purposes, this was a ban on political ads, the so-called electioneering, within 60 days of election, 2 months, right? We know that Facebook had debates. They shut down Facebook election ads for the election. This is similar thinking, right? We don't want these election ads on TV because they could distort the political market, right? let's say that one person pays all this money to criticize a candidate. People think, wow, there's a lot of criticism. Maybe this candidate's not that great. There's a lot of opposition, but in fact, there's just one dude bankrolling it, right? In McConnell, the court upheld this law. They held that the so-called soft money, right, the sort of money outside the political action committees, can be used to put these advertisements before the election, right? You can have these sort of restrictions. And the reason why was to avoid this sort of distortion. This is actually what Allison was giving me 15 minutes ago. I said no, but her answer is correct for this question. Don't worry, I didn't forget you. Right? That if you have all these people funding ads, like, wow, this is a huge issue, when in reality, it's just like one dude bankrolling like all these commercials. I mean, we all saw, oh my God, we lived through this election last year. Thank God we all survived. But we all saw this never-ending onslaught of commercials, which in reality were paid for by a very small number of people. On both sides, even Texas was a battleground state for once, right? On both sides, just nonstop, incessant advertisements. Now you might ask, wait a minute, Josh, didn't McConnell say you can't do that? Well, fast forward to 2010. In 2010, we have Citizens United. The key change was the court's composition. Justice O'Connor wrote the majority opinion in McConnell. She stepped down in 2005. Well, she announced retirement in 2005, but retired in 2006. And she was replaced by Justice Samuel Alito. And Alito was far more conservative than was O'Connor. Okay. And Citizens United was a 5-4 decision that was very controversial, hugely controversial. To this day, people want to reverse it. In fact, had Merrick Garland reversed Antonin Scalia in 2016, I suspect this case would have been reversed. Ain't happening now, but this was a case that was on the chopping block. Oh, God, I have less than 10 minutes left. All right, lecture time. Sorry. The court in Citizens United declared unconstitutional this ban on corporate spending. They reversed McConnell v. FEC, a case that was about 6 or 7 years old. So it was fairly recent. And an important aspect of this book is, important aspect of this case is we're not just talking here about movies. Under the government's theory of the case, right? Under the government's theory of the case, any corporate spending could be banned before the election. Justice Alito asked, could you ban a book? And if you go to the supplement video library, by the way, the syllabus said you have to watch the videos. That's part of the class. So if you're not watching the videos, please go back and watch them. And the front cover of your book, there's a little code. You scratch it off, and you go to casebookconnect.com. You can watch all the videos. So please watch those. Also, if you have the Casebook Connect for the casebook, our 300-page casebook, it's under the resources tab. You can find it there. And Alito asked the lawyer, can you ban books? He basically said, yeah. The case was re-argued a few months later where Kagan said, well, no, we won't ban books. But then what's the line? If the government can restrict any corporate spending, then why not books? I think this was a very damaging point for the government. They didn't recover from this one. They weren't going to. The court rejected this sort of anti-distortion risk, and they overruled some cases. Right, the mere risk that a lot of people can fund these commercials in the weeks before election isn't enough of an interest to shut down this type of speech. There were very bitter dissents on this one. Justice John Paul Stevens wrote the principal dissent. He actually tried to make sort of an originalist argument. He argued that at the founding, the framers were very concerned with corporations. And they would be shocked to see a decision like this that would have granted corporations the right to engage in sort of broad speech affecting politics. They were very worried about corruption, Stevens said. Scalia countered in his concurrence. And Justice Scalia said that the First Amendment doesn't protect speakers, it protects speech. And it doesn't matter who's engaging in that speech. the sort of question I asked at the beginning to Tori a few minutes ago, can you speak without spending money? The short answer is no, right? And in our society, the way you spend money is through the corporate form. If you haven't taken corporations yet, you'll learn this. Everything's done through corporate form. No one would risk having, liability imposed on their personality, right? They would have some sort of corporate shield to absolve that. So it's literally to ban corporate speech is to ban speech out, right? There's no clean resolution of this issue. The court, to be frank, has never really explained as originalist matter this doctrine. The free speech cases, Justice Scalia was a proud originalist, but in the free speech context, there's really not much there. That's, I think, a vulnerability for for the court's jurisprudence, because there's just not much connection between campaign finance restrictions and some sort of originalism doctrine. You'll see a lot more in free exercise and establishment clause about history, but there's just not much here. Justice Stevens said, corporations are not human beings, right? They don't have the attributes. They're not human beings. They can't be treated this way. Just a note on Justice Stevens. He read this dissent from the bench. The justice, when they're really angry, they'll read a dissent from the bench, which is like a kind of like a mic drop. And Stevens had trouble. He stumbled quite a bit. He slurred his words, and it didn't sound good. And he later admitted that he decided to retire as soon as that happened. That was the moment that pushed him over the top. He stepped down about 6 months later, and he was replaced by Justice Kagan, who had argued Citizens United. Fun fact, Elena Kagan's first appellate oral argument was at the Supreme Court, was this case. This was her very first case arguing in any appellate court ever. Imagine that, becoming a Supreme Court justice with zero litigation experience, but that's the world we live in. She had argued some case thing in Maryland State Court, like a very small matter. This was really her first big case, but she was awesome. She did a great job. So sometimes experience is overrated, but she had it. And this was also Justice Sotomayor's first case in the bench. So this was a very significant case, argued in September of 2009, a couple months after I finished law school. This is not in your reading, or maybe it is, but it's a Chief Justice Roberts' concurrence. People who took me for Conlon know my view of Roberts. It's not very favorable, but here Roberts gave his theory of stare decisis. He says, look, we should be very cautious to overrule precedent, but we can do so here because the rule was wrongly decided. I don't think Roberts would have decided Citizens United the same way after the Obamacare case. I think his sort of streak of restraint came in a couple years later. I think he was still feeling his way in 2010. I don't think this case comes out the same way today. Roberts, I think, is a different person than he was a decade ago. This case proved very controversial. About a week after this case was decided in January of 2010, President Obama gave a State of the Union address where he criticized this case. He made some statements that I think were not entirely accurate. He said that this case opened the door for foreign people to flood the elections. That wasn't exactly accurate. He also said the court overruled 100 years of precedent, more like maybe 20 years of precedent. But he made these statements. At the time, Justice Samuel Alito was in the audience, and Alito got caught on camera saying, not true, not true. And I remember watching it live like, oh, God. Alito, why are you doing that? It was bad. Alito has not been back to the State of the Union since. But this is a very controversial case. There have been efforts to amend the Constitution to overrule this case, which is just insane. It's not going to happen. Laura asks, is disclosure important? Yeah, no, it's important. It's in the case. I can't cover everything, unfortunately. I wish I could. But the court upheld the disclosure. So, this ad was paid for by people for the whatever, right? You always see those things. That at least tells you in the abstract of who's funding the ad. It's often hard to figure out who's actually funding that group, right? Where does this group get its money from? Who the hell knows? So those disclosures, I think, are of fairly limited utility, but they can be useful. Macy, go ahead.
I was just going to ask, is Buckley still the controlling precedent for specific contributions?
Yes. Yes.
Okay.
Buckley is still good for expenditures and contributions, but we're dealing with soft cash, as they call it. The rules from Citizens United. Okay, thank you for the question. Yeah, Gavin, okay.
So just to clarify on the difference between hard money and soft money. So hard money would be like that direct contribution, which is is regulated basically by the statutes, whereas soft money would be money that is indirectly given outside, isn't really regulated by statutes.
Yeah, it's these sort of the easiest examples like these electioneering where you put on commercials for the person's benefit. The difference between expenditure and soft money, I'll admit, is fuzzy. And I don't want to get bogged down in that, but for soft money specifically, we're talking about election communications, right? Advertisements before the election. That's specifically what was the concern with McCain-Feingold. But yes, to this day, contributions are about $5,000 per candidate per year or per cycle, right? So there's a hard cap on how much contributions you can make. But when you have these various political action groups, they can give a lot more. And when you have a very wealthy person, a George Soros or a Sheldon Adelson or someone like that, they can give basically as much as they want to these various groups. So I never get very excited about this topic. And the reason why is, to quote Madison, fire and oxygen, right? So long as there's oxygen, it'll make fire. The only way to put out the fire is to put out all the oxygen. And I would not be in favor of that. So long as there's a demand for money in politics, money will find a way there. I don't care if you call it a contribution or expenditure or hard cash or soft cash or whatever you call it. It won't really matter. I'm an outlier here on this view, but at this point, politicians on both sides use these committees very effectively. I don't see any movement to actually stop them. Even if there was united democratic government, they wouldn't stop them because they benefit too much from them. The amount of money that Obama, Romney, Clinton, Trump, Biden raised from these is astronomical. There were some candidates last cycle who said they would not rely on the super PAC, and they sort of moved away from that quickly once they realized they needed to compete. So long as you have this sort of arms race for fundraising, it's not likely anyone will end it. So I think there's the likelihood of getting more finance legislation is unlikely. All right. Other questions? Yes, Brian, go ahead.
A few minutes ago, you said that you don't think that Citizens United would be decided the same way today. Is that same bench, but today with today's Roberts, or is that
by Roberts,
the current justices?
By Roberts. There's still 5 votes for it, but Robert, I think Roberts circa 2010 is different than Roberts. I think he's become, don't make me talk about Roberts. I'll have to take the entire class, but I don't think he would vote the same way today as he would back then. I think he's much more concerned about stare decisis and avoiding partisanship than he was back then. Okay, thanks, Ryan.
Thanks.
Okay. All right. Okay, so let me wrap up a bit, and I'll start the minute poll. By the way, the minute poll is not designed to, necessarily say something insightful. I am just looking to see if you have questions. So if you have nothing, just say nothing. Thanks, Josh. Good class, or something like that, or awful class, whatever you want to say. But I do read these carefully, and it's my way of figuring out where I'm slacking. But just write something so I know that people are doing it, they're not blowing it off. Just write thanks or whatever. When we're dealing with the campaign finance cases, you really need to start with the basic understanding of O'Brien, right? Are these restrictions designed to suppress speech? No, they're designed to, get rid of corruption, the risk of corruption. And once you get there, you have to recognize the court has not been sort of consistent. Buckley drew this line between the contributions and the expenditures. McConnell said you can have this ban on soft cash. And then a couple years later, Citizens United said that you can not put limitations in the soft cash. This is not a particularly coherent doctrine. So to the extent I ask you a question in the exam or otherwise, the year I ask it was very important because I think the answer would probably be different depending on what year I inquire about this. Okay. Anything else? All right, I'll have office hours in about 15 minutes, or actually about 25 minutes at 2:45. I will see you all on Wednesday. Thank you so much.